Major breaking news. I've been doing some detective work over this Department of Justice brief by Pam Bondi in that NFA case down there in the U.S. District Court for the Southern District of Texas. And I think I've uncovered something very interesting and maybe very good for the Second Amendment. Warning, we're going to get geeky and connect some dots, I think, when we come right back as detectives. Hey folks, I'm Mark Smith, host of the 4 Box of Don, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, before we break down this mystery about the Department of Justice's submission in the NFA challenge case down there in Texas, I want to thank you all and let you know that I've been nominated again as the top voice of the Second Amendment in America by the 2026 Gundies Awards. And I want to thank you all for your support in getting the nomination. I guess there'll be an opportunity for you to vote for me in December. I'll let you know. I think it starts December 1st, so get ready for that. We had a big win last year. Maybe we can do it again. It's always hard to repeat, but maybe we will. All right, folks. So this is very troubling to me. As you know, I was perplexed by and surprised by the fact that the Trump Bondi Department of Justice submitted this brief in the Silencer Shop Foundation versus BATF case down there in the U.S. District Court, that's the trial court, in the Southern District of Texas. This is one of those lawsuits challenging the fingerprinting and the registration of NFA items now that the One Big Beautiful Bill signed into law by President Trump has eliminated that $200 transfer tax that ordinary people like you and I have to pay to acquire a suppressor, a short barrel rifle, or short barrel shotgun. We no longer have to pay that under the NFA. And the argument, of course, is that now that that tax has gone away, there's no longer an Article 1 congressional power that would warrant or justify the fingerprinting or the registration of an NFA item requirement for short barrel shotguns, short barrel rifles, as well as suppressors. And what is troubling to me and perplexing to me is that the United States Department of Justice, which, yes, is Bondi and Trump, submitted this like 48-page detailed legal brief in that case, arguing that the NFA remains fully enforceable and that you and I, if we want to get a suppressor, short barrel shotgun, short barrel rifle, that we still have to submit our fingerprints and register those items with the federal government, despite the fact that the $200 transfer tax went away. And as I went over a very detailed video, yesterday, I thought that the legal arguments advanced by the Department of Justice were rather weak and frankly should lose. So I did a little bit more digging because what's perplexing here is, I know no one is perfect, but this Bondi-Trump administration, when it comes to the Second Amendment, in many respects, has been very good for us. Just so you go down the list, they refused to seek cert in our win in the Reese case, which is out of the Fifth Circuit, that said young adults have a right to keep and bear arms. We won that. They didn't seek cert to the Supreme Court trying to overturn that. They also did not seek cert in the Range case that said you can have as-applied challenges if you're a nonviolent felon to federal gun control law 18 U.S.C. 922G. They are refusing to and have stopped the large capacity magazine ban in Washington, D.C. That is not being enforced by Jeanine Pirro, the U.S. attorney down there in D.C. Obviously, they're restoring rights, and we know that this Department of Justice has submitted, and this is kind of what has caused a clue for me on something. They've submitted major briefs in support of the Second Amendment in the Barnett case, which is the AR-15 large capacity magazine and suppressor ban case in Illinois. So too has this Department of Justice submitted an amicus brief in support of the Second Amendment, as well as the Seventh Circuit, also in the Third Circuit in the Cheeseman case, in support of large capacity magazines, in support of AR-15, semi-automatic rifles and suppressors, and so on. So you had all this stuff going on, and of course they supported the cert petition of the Wolford case, which we want the Hawaii law to go away, the vampire rule, and they supported cert. They filed a merits brief, and it turns out that the Solicitor General's office is actually going to argue part of the Wolford case in support of the Second Amendment. And we know that the Civil Rights Division of the Department of Justice has just brought a lawsuit against the Los Angeles County Sheriff's Department for slow walking carry permits, in addition to the fact they've just created, literally yesterday, a Second Amendment rights unit in the Department of Justice. So in light of all of this good trend stuff, favorable to the Second Amendment, I was troubled by and distressed by and perplexed by the fact that in this trial court in federal court down there in Texas, the Department of Justice submitted a brief supporting the NFA, opposing the challenge. But then I started looking into this, and there's some things here that suggest maybe something else is going on that's much more favorable to the Second Amendment. What I'm wondering is whether or not the Department of Justice is looking down the chessboard and considering pulling what many people call, and I call, pulling a Windsor. Pulling a Windsor. What exactly does that mean? Pulling a Windsor is something that arose from the Obama administration, where the federal government, Department of Justice, defends a federal law, which the NFA is. They defend a federal law or parts of a federal law in the lower courts, and they do it initially. And they do that in part to ensure, listen carefully, folks, I told you it's going to get geeky here. And they do that in part to ensure that under Article 3 of the United States Constitution, you continue to have a case and controversy because the federal government is enforcing and defending that federal law against challenges to it. Because remember, this is important to understand, folks. This is key to understand this point. Under Article 3 of the United States Constitution, just as a reminder, Article 1 of the Constitution creates the Congress. Article 2 of the Constitution is about creating the presidency and their executive powers. And Article 3 creates the federal court system and the Supreme Court. And part of Article 3 says that federal courts, including the Supreme Court, only have jurisdiction to hear certain types of cases. And one of the elements or one of the requirements for a case to be in federal court is that there's an actual live case and controversy, or case or controversy, meaning there's an actual fight about something. Here, by the Trump administration down there in trial court down there in Texas, by opposing the Second Amendment plaintiffs' arguments, is technically ensuring, as a matter of jurisdiction, that the case involving the legality of the NFA and its enforceability, despite the lack of the $200 fee, that remains an active live case and that federal courts have jurisdiction under Article 3. Because if everyone agreed there was no problem, then arguably there'd be no case or controversy, and you would never get court rulings in our favor, let's say, including from the Supreme Court, which means in the long run, we might find ourselves having to fight this many years down the road with a different Supreme Court. I don't know. Now, the reason this is called, and again, this is a geeky thing, but remember, you tune into the 4-Box of Diner to be the smartest person in the room, okay? So I have to go over this detailed information to make sure that you can debate Harvard law professors on these kinds of topics and you can hold your own, even if you're not a lawyer. So that's why we have to get into this stuff, okay? The reason why it's called pulling the Windsor, or pulling a Windsor, is because Barack Obama did exactly this strategy dealing with the Defense of Marriage Act, which is a federal law that said that marriage is a marriage between a man and a woman, and that marriages or alleged marriages between two women or two men do not count under the federal law. It's called the Defense of Marriage Act. Okay, it eventually went away. We don't need to get into that history, but it did. Now, the reason why this is important is Barack Obama is elected in 2008. In 2011, these dates are important. In 2011, President Obama stopped defending the Defense Against Marriage Act in a case called Windsor. And the Windsor case was a case involving two lesbians that got married in Canada, moved to the United States. One of them died, and the surviving spouse claimed certain tax benefits as the surviving spouse under the Internal Revenue Code. And the federal government said That's not allowed because of the Defense of Marriage Act, that deduction, that credit, that tax benefit that you want as a surviving spouse of your lesbian relationship, under DOMA, that benefit does not go to you because your marriage is not recognized, because it only recognizes marriages between a man and a woman. Now, the Obama administration initially defended this. They even submitted briefs. They argued in favor of it. They said this law was constitutional until, listen carefully, until they got to the Supreme Court. And at the Supreme Court, they switched sides and argued that the Defense of Marriage Act, this was an argument by President Obama and Attorney General Eric Holder. They argued that this law was unconstitutional, and they agreed with the Windsor plaintiffs against the federal government. But they said they were going to continue to enforce the law to make sure that they continue to have case or controversy, but they refused to defend it. Now, what's very interesting and got me thinking about this is here's a CBS News report about how the gay movement in America, the gay rights organizations in America, were very, very angry. Tell me if this sounds familiar. They were very angry at the Barack Obama administration for defending this Defense of Marriage Act in the Windsor case initially. They were very upset by that. But of course, they were thrilled when Obama in 2011, 3 years into his administration, right, switches sides. Here is the CBS News report talking about the Windsor case and the Obama administration's defense of the Defense Against Marriage Act, and then their flip at the U.S. Supreme Court. President Obama has instructed the Justice Department to no longer defend the constitutionality of the Defense of Marriage Act, or DOMA, the legal prohibition on federal recognition of same-sex marriages. The article goes on. The reversal is a major victory for gay rights advocates. After a district court ruled in July that DOMA is unconstitutional, the Department of Justice under Barack Obama, listen carefully, folks, announced that it would appeal the ruling, arguing that it has an obligation to defend all federal laws. Now, guess what happened? That angered the gay rights community, which was quick to note President Obama's campaign promise to repeal the policy. However, the Obama administration stood by its position despite this criticism, filing a legal brief in January defending DOMA. The brief argued that DOMA is supported by an interest in maintaining the status quo and uniformity on the federal level and preserving room for development of the policy in the states. Very interesting. The Obama administration defends this law to the Supreme Court, and in 2011 flips it, right? They flip it. And of course, at the U.S. Supreme Court, the gay couple, the gay argument, the gay rights movement, whatever you want to call it, wins 5-4 in an opinion by Justice Kennedy writing it in the case of Windsor. And that is why in the world of Supreme Court litigation, which you don't need to know on a daily basis, but I'm teaching it to you because you watch the 4 Boxes Diner because, you know, you want to be a high-end pro. So to be a high-end pro in this space, you need to understand that that's why it's called the Windsor case. And the Windsor case is why you call it pulling a Windsor, which is you maintain the federal government Department of Justice keeps on going defending the law, and then they flip and say they will no longer defend it when you get to the higher courts of America, including the U.S. Supreme Court. Pulling a Windsor is what Obama did in the Defense of Marriage Act, and I wonder whether or not the Trump administration is thinking about doing that down the road, because again, however you look at this brief, when you really analyze it, now it's hard to analyze it. It's 48 pages of legalese, and it's not. This is hard for ordinary people who are not lawyers at a high level to understand what's going on here. But I'm telling you, this, in my opinion, is the Department of Justice brief, quote unquote, defending the NFA is not strong. It says enough to pass the smell test. It's not frivolous or anything like that. But I gotta tell you, I don't know if it's going to succeed. I could very easily see in the federal courts in Texas finding that the NFA is unconstitutional as applied to that the aspects being challenged dealing with short barrel rifles, short barrel shotguns, and suppressors. I could very easily see a win for the Second Amendment against the NFA down there in Texas. I also want to note something that's also quite interesting. As part of my detective work here, I took a look at the lawyers. Okay, and what's interesting is if you look at the attorneys in the Cheeseman case from the Third Circuit, that's the Association of New Jersey Rifle and Pistol Clubs, and then I look at the lawyers for the Barnett case, which, of course, is the U.S. Court of Appeals for the Seventh Circuit case. Now, the Cheeseman case in the Third Circuit and the Barnett case in the Seventh Circuit are both big-time gun ban cases because these are New Jersey ban and Illinois' ban on AR-15 semi-automatic rifles, large-capacity magazines. In the case of Illinois, I think it also touches suppressors, but I can't remember that for sure right now. And I look at the lawyers in those cases, and then I look at the lawyers involved in the brief for the United States in the Wolford case just filed, and none of the lawyers that file these briefs in support of the Second Amendment appear on the brief filed in the Southern District of Texas in the Silencer Shop Foundation case. And I'm not going to denigrate any lawyer. That's not my style. But the senior officials at the Department of Justice that are involved when supporting the Second Amendment in these big cases at the U.S. Supreme Court level and at the Courts of Appeals level, they seem to be a different set of lawyers than the lawyers that submitted the brief in the district court trial court. Makes me wonder what's going on there. That disconnect that we've been talking about, why is this administration that's done so much for the Second Amendment in so many areas in less than a year, frankly? Remember, it's been less than a year. But at the same time is sort of defending the NFA, but maybe not in a great way. I don't know. The other interesting thing here is, remember, as I pointed out in my prior video, we know, and it's not going to be debated, I think in this case, that suppressors, short barrel rifles, and short barrel shotguns are under the plain text of the Constitution arms, which means the burden shifts to the government, in this case, the Department of Justice, to somehow show that they have a basis for regulating them. It could be banning you could argue they're dangerous and unusual, which is what this brief says. But if the government wants to take the position that these arms are dangerous and unusual weapons that can be banned, and they want to do the lesser thing of registering them and, getting fingerprints from people, they would have to show that they're dangerous, unusual weapons, or they'd have to show some historical tradition of registration or taxation. But if these are protected arms of the Second Amendment, they can't be banned under Heller. They can't be registered under Justice Brett Kavanaugh's dissent in Heller 2, and they can't be taxed under the Supreme Court precedent of Harper versus Board of Elections in the 60s and Minneapolis Star in the 1980s. And yet, I looked at the docket for this case, and the only evidence submitted by the Department of Justice to argue these weapons are dangerous or unusual or somehow somehow particularly dangerous or something is they just made this argument by mouthing the words in a legal brief. Very interesting, because the burden is on them, and yet, as I pointed out, they did really nothing to satisfy that burden to show they could do anything with these weapons, except cite to a bunch of old laws and cases that I'm not sure are really, they may still be good law technically, but I'm not sure they're persuasive in light of Heller, Bruin, and Catano, and so on. Now, with that said, I could be wrong in my speculation here. There could be another simpler explanation, which is that, now we're going to get geeky again. Under Article 2 of the United States Constitution, which is the clause that protects or controls and creates the President of the United States, there is a clause in Article 2 called the Take Care Clause, which says that the President has to take care to faithfully execute or to execute faithfully the laws enacted by Congress. That's part of his job. And many people argue that Article 2 language requires the President and his Department of Justice to defend federal laws enacted by Congress as a general matter. That is the presumptive thing that must occur. Now, with respect to the Take Care Clause, here is a very good discussion from the Heritage Foundation's recent book on the Constitution. And this is an article written, I believe, by Professor Josh Blackman and Professor John Yoo, both very good guys. Here's what it has to say about the Take Care Clause. The Article 2 vesting clause grants the executive power to the President. The Take Care Clause qualifies that power. The President must wield his executive power over law execution to take care, quote, take care that the laws be faithfully executed. Close quote. The president must use the constitutional and statutory resources at his disposal to see that Congress's laws are executed faithfully. So in light of that, it's possible that DOJ just feels the obligation to defend these laws in court for the moment because of the Article 2 obligation the president has to take care to make sure that Congress's laws are executed faithfully. On the other hand, it's possible also that this Department of Justice feels that or thinks that it makes sense to continue to defend federal laws and push to the Supreme Court lawsuits involving state laws, because if you look at the Supreme Court record over the last couple decades, Heller was involving a local law with D.C., McDonnell was involving a local law involving Chicago, Katana was involving a Massachusetts state law, Bruin was involving a New York state law, and we won those cases against state laws. Likewise, in the current Wolford case against the state of Hawaii, we're likely to win that case. So if you look at the Second Amendment cases we've won in the Supreme Court over the last few decades, they all involve challenges to state and local and city laws. In contrast, if you look at the Second Amendment cases that have lost on our side, that's Rahimi was a federal law. Hamani, which we're going to lose this term, involving pot and guns, is a federal law, right? You can see where I'm going with this. And even United States versus Miller from the 1930s is a federal law that was upheld. So in that particular context. So the Department of Justice may just think that the institutional wing of the Supreme Court, led by Chief Justice John Roberts, and maybe even Associate Justice Brett Kavanaugh could be in that category, that they may not want to knock out federal criminal laws, but they might be comfortable using the Second Amendment to knock out state laws, at least for the moment, until there's more precedents on the books that can then be used to advance the ball against federal gun control laws. Again, this is a strategic choice. I don't work for the Department of Justice. I'm not in the Department of Justice. I don't have access to all the information they have about the political dynamics of what's going on in certain quarters of Washington and so on. So again, are they setting up a Windsor maneuver here? They're just not telling us about it because they don't want to raise this issue with the anti-gunners and stuff. I don't know. Or are they just simply executing and enforcing the law under Article 2 of the U.S. Constitution, the Take Care Clause, which is what most administrations do 99% of the time when it involves federal challenges to federal laws? I don't know. I'm simply flagging this as a possibility to make you the smartest person in the room. I want to give you these things to think about because sometimes this is much more complex than just screaming shall not be infringed. And that's why you tune into this channel, to think about these deep and serious thoughts. And I just want to remind you all, we should still remain very optimistic about the Second Amendment in America because, again, just look at the trend for permitless carry and other things. I'm still optimistic we're to keep our gun rights. Of course, we have to solve immigration, but that's a topic of another day. All right, folks, so there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at @4boxofnard. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.